Well, it looks like it is noon and we are going to go ahead and get started with our webinar today. It's our class action alert, Pacific Northwest employers in the crosshairs for meal and rest period claims. My name is Leah Lively, and I am a partner in Buchalter Law Firm's Portland, Oregon office, but I also am licensed in and practice in California and Washington, as well as Idaho. Along with me is my colleague, Alexandra Schulman. You'll probably hear me refer to her as Alex. Alex is a senior counsel in our Portland office, and she's also licensed to practice in Oregon and Washington. Today, we'd like you, if you have questions throughout the presentation, to use the Q&A function that is at the top of your screen since you're using Zoom. So just put it in the Q&A. That goes directly to me and Alex and not to the group. If there's something that you want the larger group to see, then you'd go ahead and use the chat function. So we're going to get started and head right into it. So the first issue is sort of, what are we doing here? What we're going to talk about today is a number of things. One, we're going to talk about why does this matter? Two, we're going to talk about what are the rules that we're dealing with and that you need to know about for proper meal and rest period compliance. Three, we're going to let you know what you should be looking for in your payroll records or in your systems in order to reduce your risk and increase compliance. Four, we're going to give you some tips and strategies on how to be compliant and reduce your risk exposure. And we're also going to let you know what to do if you have a problem. I've represented a lot of employers over the last 25 years, and no payroll and pay practices are perfect, and there's always problems. The key is to know what you can do to try to avoid those problems and what you can do if you find a problem. So why does this matter, number one? Well, as you can see, these are headlines from local Pacific Northwest newspapers or online papers. And all over the place, you're seeing companies settle huge meal and rest period violation cases. Alex and I get a court reporting service that tells us what cases are filed on any given day in Washington and Oregon. And Washington lately has had a huge uptick in the number of class action meal and rest period cases, which is part of the reason why we're here today. So one, this matters because of lawsuits. Lawsuits are expensive. And it doesn't just mean you are a huge, big ticket employer. It's not just the Walmarts or the Jack in the Boxes. You have smaller employers and franchises, 7-Eleven stores, the Willow's Inn. Even small employers can have problems with meal and rest period compliance that they need to know about. Why else is this important? Because it's expensive. Not only the lawsuits, but the attorney's fees. If you get hit with a meal and rest period case or demand letter, you're going to have to pay your attorney's fees. And this is what Alex and I do. We represent employers dealing with these cases and helping them out of these cases. But you're also going to be expected to pay, if you lose, the other side's attorney's fees. And it only goes one way. They don't ever have to pay your attorney's fees. If you make meal and rest period violations, or if you have meal and rest period violations, chances are you're not just going to get sued for those violations, but you're also going to get sued for different violations, such as record-keeping violations, minimum wage violations, failure to accumulate sick time violations, overtime, and particularly problematic in Oregon, failure to pay wages at termination. Because the argument is, if you didn't pay for the meal period, you haven't properly paid all the employees at the time of termination. Next, penalties. The federal law, as well as both states have penalties for violations of wage and hour laws. In particular, in the state of Washington, as you'll see, we've got some pretty hefty penalties for meal and rest period violations. Next, bad publicity. I hope none of you are the front pages that we have here on this slide, but you don't want to be. And next, it's just poor morale. And employees don't want to work for a company that doesn't pay them correctly or is in the front page. So when we talk about damages, I realize this is my scare tactic on sort of slide number 3, but let's talk about damages. I'm going to give you a little fact pattern. You have Ed employee. He's worked for the company for 3 years and he makes $22 an hour. Over a 3-year period, he takes a short 25 to 29 minute meal period every other week. So there's 78 short meal periods. And by the way, Washington does not have a de minimis exception. So the 1 or 2 minutes, it means a legal violation. In addition, once a month, Ed takes a late meal period. So he comes after the 5 or the 6 hour mark. So he's got 36 untimely meal periods. Now he's a good employee. He never complains about his non-compliant meal periods, and he quits for a better job and is timely paid in his final paycheck, everything other than these meal periods. What are the damages? They're pretty big. So first of all, we've got 114 non-compliant meal periods. So 114 times just owing him for the 30 minutes for each time he missed. Even if he got a 29-minute meal period, you don't owe him for the 30. You don't owe him for the 1 minute. That's $1,254. Under Washington, you have penalty wages. That's $1,254. So just for Ed in Washington, you'd have $2,500. You have 45 Eds and you're already in a 6-figure case, and it adds up fast. But in addition, you have minimum wage violations, overtime violations, potential sick time accrual violations, attorney's fees, individual liability for some claims. And in Oregon, the failure to pay wages at termination is 30 days at 8 hours a day, including weekends, that you owe that employee. So as you can imagine, that's going to, for Ed, add up to another $5,000. So now just for Ed, for him taking short or slightly late meal periods, you're going to owe Ed about $7,000 or $8,000. It adds up fast, and it's easy to let it go because it seems small at the time. So what are we going to talk about? We're going to talk about next what the laws are and what you need to do, and I'm going to turn it over to Alex.
Yeah, so meal and rest period laws are governed by state law. And so you need to look at what state the employee is working out of to determine which law you need to follow. Oregon and Washington are somewhat similar, but they do have their key differences. So we're first going to address basics that cover both states. Meal and rest period laws apply only to non-exempt employees. So that's typically hourly employees. They're not paid a salary, and it doesn't cover people who are exempt under any of the FLSA exemptions, classifications, or state exemptions. And these non-exempt employees are entitled to unpaid meal periods and paid rest breaks, depending on the length of the shift that they work. In most cases, if someone's working a normal full-time job, that's going to come out to 1 meal period and 2 rest breaks per shift. Meal periods need to be at least 30 uninterrupted minutes, and uninterrupted is the key there. You can't have a meal period where the employee is off for 15 minutes, gets pestered with a couple of questions for 2 minutes, and then goes back, and then only has 30 minutes. In that case, they need to have a full 30 uninterrupted minutes, and we'll talk about that in a little more detail later. Rest periods need to be at least 10 minutes, and it's the same thing. They should be uninterrupted. Meal periods and rest periods can't be combined. So a lot of times you'll have an employee request, can I just, take a longer lunch and combine my meal and rest periods, or can I come in late and just not take my meal and rest periods? The answer is no. And that goes hand in hand with the next bullet point here, which is that employees cannot choose to skip or modify their meal periods unless a certain exception applies, which we're going to cover. So let's talk about Washington meal periods first. And this gets a little bit dense, but I will do my best to kind of walk through it slowly and methodically. So in Washington, to determine when the meal period needs to happen, first of all, the employee has to work at least 5 hours in a shift. So if an employee works only 3 hours that day, they don't need a meal period. If they work at least 5 hours, they need a meal period. So when do they get to take it? The meal period must start between the 2nd and 5th hour of the shift. So if an employee starts work at 7 a.m., they can take the meal period anytime between 9 a.m. and noon. And that's just when the meal period needs to start. So if they started at 11:59, that's great. If they started at 12:01, that's a late meal period. And then, and it, like Leah mentioned, there's not a de minimis exception in Washington. So if the employee truly did take a late meal period, even if it's only late by a minute or two, that's considered a violation under the law. And that is a meal period that would need to be paid, because it's considered a missed meal period. Even though the employee is getting a meal period, it's a little counterintuitive, but they are actually considered to have missed that meal period if it happens after that 5-hour mark in Washington. Now, if an employee works 3 or more hours longer than a normal workday, they should be allowed at least one additional 30-minute meal period prior to or during that additional period of work. This comes up less frequently because, you know, that would require it to be a pretty long work day, but it is something that you want to keep your eye out for, especially when you have circumstances where employees might be working more than usual, you know, for instance, holiday hours, or a situation where you have an uptick in work. And go ahead. A meal period must be unpaid, or can be unpaid, if the employee is free from all duties for the entire break. Employees can only be required to remain on the work site during the meal period if they're completely free from duties. So it's not sufficient to have an employee work at their desk and keep an eye on their phone and answer the phone during their meal period, just in case someone calls that's important. That's considered still being on duty, and that's not sufficient. But if the employee is sitting in a break room, eating their meal period, no one's interrupting them for lunch, that's okay. A meal period must be paid if the employee is remaining on duty, such as listening for the phone. If the employer requires the employee to remain on call, even if the employee is never called back to duty. So let's say the phone never rings, while the employee was still responsible for sitting at that desk just in case it did ring, or just in case someone comes up the elevator who might need to be greeted, that meal period needs to be paid. And the employee must be paid for the meal period if the employee is called back to work, interrupting the meal period. So that's what we talked about earlier. Let's say the employee is working for 12 or on the meal period for 12 minutes, gets a 2-minute interruption, and then gets to go back to their meal period. That whole meal period needs to be paid now. And on top of that, they still need to get 30 minutes of uninterrupted time. So if they are interrupted during that meal period, they need to be paid for that meal period, or they need to be paid for the time that they're interrupted in performing work, plus they need to be paid 30 minutes for the meal period. So in the situation I just mentioned where they were interrupted for 2 minutes, they're paid during that 2 minutes, but then they're also paid the additional 30 minutes. So that's 32 minutes that need to be paid. Work performed during meal breaks is considered hours worked when calculating paid sick leave and overtime. And that dovetails with what Leo was saying, which is when we see lawsuits for these, they rarely are just for meal period violations, because what will happen is someone works 40 hours a week and doesn't get paid overtime. But then once you add in 30 minutes of a meal period violation, all of a sudden that's not only time that wasn't paid for the meal period violation, but it's overtime that wasn't paid.
Alex, we have a couple questions that I think we should go ahead and answer right now, since we're in the thick of it. One of our questions was, what about a lunch meeting during a normal work day? Does that count as a meal period, or are you going to have to pay the person for that?
You're going to have a
working lunch meeting.
So a working lunch meeting would need to be paid, and you should still provide 30 minutes of uninterrupted time to the employee.
And if the employee is paid for their meal period, they're getting paid meal periods, they're not clocking in and out, or do you still have to pay them for 30 minutes if they miss their time?
Yes, they get that 30 minutes of uninterrupted time, and that's the key. And that's one thing that frequently employers run into trouble, which is, you know, hey, we paid them, what's the big deal? But the point is they are entitled to that extra 30 minutes of uninterrupted time.
Okay, those are the questions.
Okay. And I think we can move to the next slide. Okay, so those are kind of the Washington meal period basics. What about Washington rest periods? What is a rest period? A rest period means to stop work duties, exertions, or activities for personal rest and relaxation. So, search your phone for, shopping or make a phone call, anything like that. The employee must receive a 10-minute rest period for every 4 hours worked. And they cannot be required to work more than 3 hours with the rest break. So what that means is basically, let's say you have an 8-hour shift, you're going to get 2 rest periods in that shift, and they should be taken towards the middle of the shift. So, 2 hours in and 6 hours in a perfect world would be when the employee takes their rest period. And employers can require workers to stay on the job site during a rest break, but again, they should be uninterrupted during the rest break. In Washington, you do have the option, depending on the nature of your business, to have intermittent rest periods. So this means that the employee can take several mini breaks per 4-hour period of work, as long as they add up to 10 minutes. We see this in, like a service type industry where you have patients coming in and out, and there are natural periods of time where employees have breaks, and they could, let's say, in between patients, you always get about 5 minutes. And so, that employee is getting, actually closer to 20 minutes per 4-hour period of break time. That's a good example where intermittent rest period might work for your business. Okay, so that's Washington. Moving on to Oregon, it's slightly different. Oregon, you have to look at how long the shift is first to determine when the meal period should be taken. So if the shift, first of all, it's a slightly longer requirement for when a meal period is owed. If a shift is 6 hours or more, then you must pay a meal period. So unlike in Washington, where it was 5 hours, you actually have a little more leeway as far as, okay, if they work 5.5 hours, you don't have to pay a meal period or provide a meal period in Oregon, whereas you would in Washington. So if that shift is 6 hours, but less than 7 hours, then the meal period is like Washington and must commence between the 2nd and the 5th hours worked. But for most shifts that are more than 7 hours, the meal period should be taken between the 3rd and the 6th hour work. So in the example I give in Washington, let's say the employee comes in at 7 o'clock. Instead of the meal period being taken between 9 and 12, in Oregon, the meal period would be taken between 10 and 1. Additional meal periods are required to be provided to employees who work 14 hours or more in a shift. So if they work at least 14 hours, then they're going to get that second meal period. And Oregon's Bureau of Labor and Industries actually has a really handy chart that'll break down exactly how many meal and rest periods per length of shift. So if, let's say, it's a 9-hour shift, it'll tell you exactly how many meal and rest periods you need. So that's always a good way to check your math and make sure you're understanding it correctly. Like in Washington, a meal period may be unpaid if the employee is free from all duties during the entire break. If the employee is required to remain on premises, as long as they're relieved of all duties, it can still be unpaid. If they're on call during the time, they're not relieved of duties. So like in Washington, that would need to be paid. Now, Oregon rest periods are a little bit different from Washington in that they do not allow for intermittent rest periods. So in Oregon, you do need to closely monitor that employees are truly getting a 10-minute rest period. And so like in Washington, they must receive a 10-minute rest period for every segment of 4 hours or major part thereof worked in one shift. And like in Washington, it should be taken towards the middle of the work segment. And like we touched on before, you can't let employees combine their rest period with their meal period to get a 50-minute meal period. The You need to make sure they're getting that rest period at around hour 2, taking that meal period around, let's say, hour 5, and then after they get back from their meal period, they take another rest period about 2 hours later. It looks like we have some more questions.
Yeah, I was going to say, Alex, before we get to the next slide, do you want to go ahead and answer the questions?
Yes, okay. Let's see, if employee was paid for the meal period, does he or she need another unpaid 30 minutes? I think we answered that one.
Yes, we did.
What if it's not a lunch meeting, a manager takes a couple non-exempt employees out to lunch for social purposes? Do those 2 employees still need a 30+ minute lunch break before or after the lunch with their manager? That's a little tricky because, and that's a great question. If business is brought up, I would say yes, they need to be, and it's going to be kind of your word against theirs as to whether or not business is brought up. I would say the safe assumption is to provide it. Now, if it's truly 100% social and no business is brought up whatsoever, then no, it doesn't need to be paid. But I do think that that's a bit of a gray area. If you are a commercial truck driver, do you need to clock in and out for meal periods and rest breaks? I don't actually know the answer to that. I think there might be some unique laws for commercial truck drivers. Leah, do you know that off the top of your head?
There are, and it's a preemption issue. And so we should probably follow up with whoever this is, because I believe that at least in Washington, they decided that, well, there was preemption, that the Washington rules still applied, but I haven't looked at that issue in some time. And so if whoever, it's an anonymous attendee, unfortunately, wants to reach out to us, or maybe one of us can look this up. In the meantime, maybe Alex, while I'm going, you can look into that. I know that there's a preemption issue under federal law for that.
Okay, the next 2 questions I think we're going to cover later in our presentation. How do you document these intermittent rest periods? We're about to cover that. And if you are taking intermittent rest breaks, do they need to be recorded? Is the employee punching in and out for mini breaks? We're going to cover that pretty soon.
Yeah, the question was, does the lunch meeting rules apply in Oregon as well? Yes, that's the times are a little bit different as far as the 2nd, the 5th hour, and the 6th hour, but those basically are going to apply, and it's going to be the same question of 30 uninterrupted minutes.
Okay, can you discuss documentation of break periods? We're about to get to that. In our clinic, our employees do take an intermittent break waiting between patients, but do we have to track them? They're not always checking their phones. Okay, I guess we're hitting the nail on the head here with our next topic, because that's the question everyone has.
Yeah.
Documenting rest periods. Yes, I think.
Go ahead, Alex.
I think we should go ahead and move on to the next slides, because most of these questions I think will be covered.
Yeah, and just rest breaks are hard because people don't clock in and out for them. And so there are ways around that, which we're going to talk about, but generally most employers don't have people clock in and out because they're paid anyhow and they're short. So let's talk about what you should be looking for, which hopefully is going to address some of that. The first thing that you need to be looking for is you all need to understand what data that you have. Different employers have different things. So you may have schedules. Are you putting your meal periods on those schedules? Are you putting your rest breaks on those schedules? You may have punch detail reports when somebody punches in, when somebody punches out. Some employers, where my husband works, they go into a computer and say what time they are in and what time they're out, as opposed to using a punch card. And you have your paychecks, which obviously show the hours worked and that sort of thing. So the first thing you need to be doing when you're figuring out where do I have exposure, what are we potentially not doing right, is understand what you have and who's the keeper of that information. The next thing is you need to understand what safeguards you have and you do not have. So let's talk about what some of those safeguards are. And we're going to talk about them more later when we sort of give you our best practices. One, and hopefully you know, a lot of employers have a third-party vendor, an ADP sort of vendor that's doing their payroll. Some people are still doing it in-house, and depending on whether you're doing it in-house or whether you have a vendor may lead or may be the reason why you do or do not have some of these safeguards. But the first thing that you need to know is, do you have punch error reports? In other words, if somebody's clocking in, and this is good for not just meal and rest periods, but this is good for off the clock work and all sorts of wage and hour issues. Do you have an error report if somebody A has an uneven number of punches at the end of the day, and B, if they go under 30 minutes? You should have that. Knowing whether your employees are clocking out for meal periods of less than 30 minutes is really important, and is going to be, if you get sued for this, is going to be something that you have to turn over and show. So do you have punch error reports? If you don't, can you get them? You really need to have them, unless you have such a small number of employees that you can check things by hand. But somebody needs to be looking for short meal periods, and somebody needs to be looking for late meal periods. And that, I know some of the big vendors have the ability to put that in, because meal and rest period litigation is huge in California, and a lot of employers have gone to that. Next, do you have the ability to make corrections? Now, this one has an asterisk by it, because if somebody has a missed punch, right, forgets to punch, you need to be able to go into those documents and put in, oh, what time did you clock out? I clocked out at 3:30. What time did you clock back in? It was 4:01, right? My caveat here, and the reason there's an asterisk, is because you need to have a record of who made that error, who made that correction, and that the employee is approving of that correction. I tried a huge off-the-clock claim many decades ago, and the issue was people were saying their managers were going in and shaving off their time so that it didn't go into overtime. Now, this isn't a meal and rest period issue, or that wasn't there, but it could definitely go there, especially if you have a manager who's putting in meal periods and the employee is later saying, I didn't take those meal periods. So you need to make sure and have a trail of who's documenting and that the employee is approving that. The approval can be by email. It can be an auto-generated email. It could be something that they sign off. It doesn't have to be super sophisticated. Obviously, the larger your employer is, the more sophisticated you probably need it to be, because you just have more employees to deal with. But you need to be able to make corrections and document who made those corrections and that the employee had buy-off on it. Next, are you doing acknowledgements? And what I mean by acknowledgements is an employee, you send out an email at the end of each work week saying, you know, please acknowledge that you received all your meal and rest periods or took all your meal and rest periods this week. You know, maybe it's a voting button, maybe it's a click, like a doodle poll sort of thing, whatever it happens to be. Do you have acknowledgements? That's a really important thing to do. Whether it's sophisticated or not sophisticated, having those acknowledgements is important. Next, do you have auto payments set up? This is not something that all employers do, but some employers have gone so far as to, when their time clock shows a short meal period or a late meal period, it just automatically pays the employee for the 30 minutes. That's not an uncommon thing to have in California. And last, you've got to audit your time records regularly. And you're thinking, okay, what do you mean by audit my time records? You've got to print out, maybe it's your a 10% or whatever. It doesn't have to be everybody's records, but a good random sample, morning, afternoon, evening shift, Mondays and Wednesdays, whatever it happens to be, and look at that, or have us look at that. This is going to be, depending on your employee size, a few $1,000s up to maybe $5,000 well spent. And if you have us do it, we can do it where it's attorney-client privilege, so that somebody can't get to it later. But if you can't have us do it yourself. And if you need guidance on how to do that, let us know. We're happy to do that. But if you don't know what information you have and you don't know what's happening within your information, then you can't fix it. And that's where our employers tend to get into trouble. So let's just take a look at some pay stubs or some punch. This is what I would consider punch detail reports. And I took the employee's name off and the employer's name off, but we've got 3 of them here. So the first one you can see that that there is this person clocked in at 2:01 and clocked out at 8:15 and worked a total of 6.23 hours, but they don't have any sort of meal period. So that right there is going to be a meal period violation. Over 5 hours, no meal period. The next one you have an employee who's clocking in at 7, let me see, we've got them at 7:44 a.m. They're clocking out for the day at 4:20, and they take their meal period at 12:56. It looks like they're in compliance with there, but they are over 5 hours, right, with no meal period and less than 30 minutes. So it's a 0.40, but 0.50 is going to be the 30 minutes. So they don't have a meal period. This last one is really problematic. So in this last one, you have the employee clocking in at 5:40 a.m. and you have them clocking out at 7:09, and they don't take the meal period till 3:30 in the afternoon. And then of course they only take a 13-minute meal period. So this one, you have the person going over 5 hours with no meal period, less than a 30-minute meal period, and it's late. Now, the good news is you're not going to owe them 3 meal periods, right? There's still just one violation here, but nonetheless, this is how easy it is. I mean, there are 3 errors on this last time card, and that's where those violations, as you can imagine, kick in really quickly and really easily, and that's why you've got to know what you have. So I'm going to talk about some, I don't know how to get rid of this, some common misconceptions that we've got here. Sorry about my scrawling. I'm going to have to figure out how to get rid of that. I don't know. Clear all drawings. All right. Thank you for bearing with me on that. So we're going to have to talk about now, what are some of the misconceptions? One of the misconceptions Alex already touched on, and that is assuming that a tiny interruption to the meal period doesn't matter, right? Somebody's sitting at having their lunch, you come by, you say, hey, Bob, did we ever get that order in? And Bob says, yeah, we got it yesterday. That's an interruption, okay? That starts the clock on needing a new meal period. They either need to start over right then or you need to pay them. So it's really important to train your employees and your supervisors and managers to say no to workplace interruptions. I can't help you right now. And to encourage them to report the interruptions, because chances are you're going to find that it's the same manager or supervisor that's going around doing this. Now, sometimes interruptions happen, right? We know that. Sometimes things come up. I know a lot of the dental and medical practices, you have patient issues where something is going to happen out of your control. Pay the person for it. Make sure they report that interruption and pay the person for it. That 30 minutes of lunchtime is not worth the class action or the lawsuit down the road. So train and then consider disciplining the interrupter. Alex is going to talk about the importance of disciplining people, whether it's the employee or the supervisor, for these sorts of violations. It seems harsh, but you've got to do it. And in this situation, consider disciplining the interrupter. If it's a one-off thing, that's fine. If it's a true emergency, that's fine. But if there's a pattern, you need to do something about that. All right, the next one is, and I hope nobody here is doing it, is making automatic deductions for meal period. That's my head exploding if you're doing that. So let us know if you are. Automatic meal period deductions, 30 minutes, are the single most dangerous way of inputting meal periods, because people are going to invariably say, I didn't take a meal period, I took 25 minutes, they just told me to write 30 minutes down, and you now have no way to prove it because you don't have sort of real time punches, which is what the law requires you to have. All right, next, we talked about this already, time card corrections without accountability. You've got to have that trail and you've got to have the acknowledgement. Next, assuming that no complaints means no problems. We have a client who didn't have any complaints about their meal periods and their system. It was a medical dental practice, and the way the scheduling worked, people got their meal periods later in their shifts. Nobody complained about it until somebody complained about it. And then you looked at the records and it needed to be fixed. So don't assume just because you've got great employees and they're not complaining that there isn't some sort of violation that one disgruntled employee later on can really exploit. All right, don't assume everyone knows the rules because it's written in the handbook. Now, as litigators, Alex and I like to say it was in the handbook. You knew it, you knew it, you knew it. But the reality is when you are trying to reduce exposure and be compliant, you don't want to assume. You want to have reminders. Maybe you have morning meetings. Maybe people get weekly or monthly emails. Maybe there's something left in their inbox. Whatever it happens to be, have reminders and document or keep a hold of, if you're the person sending the reminders, keep a hold of those so you can prove this is what we did. Unfortunately, in Oregon and in Washington, the courts have said that providing somebody a meal period or a rest period essentially means forcing them to, right? It doesn't mean offering it. It doesn't mean creating the opportunity. It means making sure that it happens. And so the onus is on you as the employer to say, this is what we did to make it happen. All right. And last is assuming you only need to offer, I just said it, offer employees the opportunity to take compliant meal and rest periods. You've got to do more than that in the state of Oregon and in the state of Washington. Okay, so now that we've talked about what you have to do, let's talk about what the court is not going to care about. So these are things that will not save you from liability. First, we had a patient emergency. The court is not going to care that somebody came in from an accident or, thinking of all the dental things that I've gone through, something goes wrong or that a child is having a hard time. They're not going to care about that. So you have to either in Washington get a waiver, maybe you apply for a variance, or just pay the person for those 30 minutes if it doesn't happen. The next, the court is not going to care that the employee worked past their scheduled shifts, and even though they shouldn't have gotten a meal period, didn't get a meal period, or now went into time where they needed a meal period. You're going to need to pay them. The court is not going to care that you had this lovely schedule. It's good to have it. It's good to show that you're trying to make employees do the right thing. But at the end of the day, you are responsible for making sure employees take their meal periods on time. And you can't say, but it was on the schedule. I mean, that's a place to start. But if the employee doesn't take their meal period on time, you're going to need to discipline that employee or pay them for that meal period. The court is also not going to care that you are a nice employer. Okay, they're not going to care that you gave the employees extra smoking breaks or let them make personal calls and play Candy Crush on their phone and they really got more than 10 minutes every 4 hours. It's just not going to care. You've got to be able to show, particularly with meal periods, those time clock records. All right, the court's not going to care that your employees don't want to take their breaks. So I have a number of restaurant clients and tipped employees do not want to take their meal period breaks, right? They're giving up on tips, they're giving up on their table, it's interrupting the customer flow. Unless you have a waiver, you've got to make them take their breaks. It's just unfortunately something that you as the employer have to do. All right, the court's not going to care that you were shorthanded or understaffed, and the court's not going to care that you didn't know that these employees weren't getting their meal periods. So in Oregon and in Washington, I think one thing that trips employers up is the term willful, because they read in the statute that you're not going to get in trouble unless it's a willful violation. And here's my favorite, Princess Bride reference here of willfulness is the courts in Oregon and Washington and to a large part in California have really just read willfulness, interpreted willfulness out of the statute. It doesn't have to mean you intend the people not to get their meal period. It means you intend to pay them how you intended to pay them. So it's really done away with any practical meaning of the word willfulness. So if you see willfulness in the statute, don't assume that means you have to be the bad guy and that's the only way you're going to get in trouble. All it means is that you meant to sign that paycheck or you meant to have your timekeeping system. So it's really important that you come up with a system to ensure people are getting their meal periods and rest breaks. And with rest breaks, there's a lot of questions about documentation. Employers, I don't think there's a reasonable way to document the rest period unless you're a very small employer. But what you can do is have acknowledgments that employees took their rest breaks and very clear processes in place for what an employee should do if he or she did not get their rest break, or they think they didn't get their rest break. And that's sort of the best you can do. I mean, sort of the big ticket items are the meal period claims. That's where they're really going to get this automatic 30 minutes because you've been paid for the rest break, right? It's not quite the same. But we see them go together. But for the rest breaks, it's not so important. You can document it, but that's onerous for most employers. What you can do is have that acknowledgement. The acknowledgement hopefully can be pretty straightforward with an email, with a sign off on the paycheck, with something like that. All right, I'm going to turn it back over to Alex now to talk about some more practical tips of what you can do to reduce your exposure.
I just want to clarify one thing because it might get misinterpreted. When Leah said that you've been paid for the rest period, that's true, but you still need to pay an additional 10 minutes if the rest period is missed, because it's considered, it's a little counterintuitive, person's been paid, but it's considered 10 free minutes basically, because you were supposed to pay them 10 minutes that they weren't working, but instead they weren't working during those 10 minutes. So you still need to pay them for those 10 minutes. Okay, so we've thrown a lot of information at you. These are the laws, these are the problems, these are the things courts care about and don't care about. But what can you actually do as a practical matter to reduce your risk and exposure? The number one thing you can do is update your policies and start with a compliant Oregon or Washington policy, depending on where you're located. So often we see clients that have a generic meal and rest period policy that says we offer meal and rest periods in compliant with applicable state, federal, and local law. Okay, great. That sounds nice, but what does that actually mean? Does that tell the employees when they need to take the meal period, or how long the meal period needs to be, or the reporting procedures if they miss the meal period and how they get paid? No. So it's really hard to, if you are sued, to be able to point to that policy and use that as a way to at least argue, hey, employees knew what the meal periods were, they didn't report violations, so there's at least arguably a waiver of the meal period, or any type of argument like that. And it also is going to increase the likelihood that you're going to have violations because people just don't know what the law is and don't know what the requirements are. The next thing you can do is have accurate and thorough documentation. Leah already touched on this, but all of your meal periods should be documented through timekeeping, and you should have kind of checks and balances for being able to see when there's a short missed meal period, late missed meal period, anything of that nature. And then for rest periods, that's a trickier one. It's hard, you're not clocking in and out. So that's typically not shown on time card reports. But one thing you can do is either have some payroll providers will offer an option where employees can acknowledge taking their rest periods for each pay period or each shift, or however they have that set up, or you can come up with your own internal mechanism for doing that, whether that's an automated email that's sent out every week or every pay period or something like that. But documenting that those rest periods were taken, and if they weren't taken, having a mechanism for an employee to report that it wasn't taken, other than just relying on the employee coming to you, like having an automated email that goes out and says, did you take it or not? If the employee, if you don't respond, we will assume that you did take it. And that way it's, obviously it's better if the employee responds and says, yes, I did take them. But that way you can at least argue, hey, we affirmatively asked them if they took that rest period and they never came back and said that they didn't. And then proactively compensating employees for missed meal periods and rest periods. So that there was a short meal period this week. Pay the employee for that short missed meal period.
So Alex, can I stop you for a second? We had a question on this, and it was, what do you mean by pay employees for a meal period? Like, what functionally does that mean? Does it show up on their paycheck? How does the time go in? Can you explain what that means by paying employees for their missed meal period?
So it's just paying additional 30 minutes. And as far as what exactly that looks like on the payroll I don't know. Leah, I think it would depend on the payroll provider, how it gets logged in or what it shows as.
Yeah, it shows wages. So because it's just like if you worked through a meal period. So a lot of times what the payroll provider will do, an experience with employers in California, is it'll literally say a meal period on it. Because remember, in both Oregon and Washington, you have to state the hours worked, the rate of pay, and excuse me, I'm so sorry. And for your own exposure risk reduction, you would want to show what you paid. So if somebody came back later and filed a lawsuit, you could say, I already paid this person for that time period.
Okay, and we had a lot of questions about how to document intermittent rest periods and rest periods in general. And that's just what I touched on, which is you're not going to necessarily clock it like, or, have records like you would a meal period where people are clocking in and out because they're already being paid. But you want to have some type of mechanism, whether it's via the payroll provider or some type of internal system for reporting taken and missed rest periods. And that's the best way to document it. And that applies for intermittent rest periods. And that applies for just regular 10-minute rest periods. You can do it the same way.
Oops. Okay.
Okay, what else can you do to reduce your risk and exposure? Enforce your policies. So you have that great Washington or Oregon compliant policy. Now you need to enforce it. Create a schedule that's compliant with your state's applicable law. So if you're in Washington and you open at 7 a.m., make sure people are taking lunch by 12. If you have a regular lunch period, that regular lunch period should be, let's say, 11:30. That way you have a little bit of wiggle room for when, if someone is a little bit late getting to their lunch, well, you're less likely to have a violation. Discipline employees where appropriate. As Leah mentioned, that sounds kind of harsh, and it doesn't have to be as harsh as it sounds. If someone takes a 28-minute meal period and you have to pay them, first time it happens, you can just say, hey, you're getting paid additional for this short meal period because it's in compliance with applicable law. But it's important that you take your 30-minute meal period in the future. And if you continue to not follow the policy of taking at least 30 minutes, there will be more discipline, whether it's a formal write-up, and then if it continues up to including termination. If you have someone who says, hey, I'm going to game the system and always take a 29-minute lunch break so I get a free 30 minutes every day, that's probably someone who's eventually going to need to be terminated. And an employer's recourse for a policy violation is to discipline the employee. So we hear a lot of employers say, well, hey, this wasn't my fault. Why do I have to pay them? Like, I gave them the opportunity for this meal period. They chose not to do it. They didn't follow the policy. We reminded them they needed to do this. They still didn't do it. I don't want to pay them. No, you still have to pay them. Your only recourse is to discipline the employee. And that's why it's important to have a game plan as far as, okay, what do we do when there's just a couple of isolated violations versus habitual offenders, and how do we handle that? And how do we do that in a way that is uniform across our organization and not discriminatory towards any particular types of employees? Now in Washington, you have a unique option of being able to obtain employee waivers. So let's say you have employees who say, I don't want to have to take my meal period between the 2nd and 5th hour work. I want to take my meal period whenever I feel like it. Well, they're a great candidate for signing an employee waiver. They're saying, hey, I don't care about Washington law. I want to take my meal period when I want to take it. But you want that waiver in writing. And that's something, depending on your organization and what the situation is, we could help you with developing what that waiver form would look like in your case. Now, in Washington, you can technically have an oral waiver, and that might work in some scenarios. Let's say, there's an emergency and, patient emergency, and the employee says, hey, no, I'm going to stay. I'm going to help out. I really want to help this person. And you say, well, no, you need to take your meal period. And they say, no, I don't care about my meal period. Well, that's an oral waiver, and you would want to document that in some way after the fact. But generally speaking, for a waiver, you want to make sure you have it in writing. In Oregon, you can't have a waiver except if the employee is serving food and beverages and receive tips and report their tips to the employer. And there is a specific form on the Bureau of Labor and Industries website that needs to be completed for that waiver. But that's, again, just in that very specific industry. In neither state can you waive rest break entitlements. So you can waive the meal period, but not rest breaks. Those need to be taken regardless of what the employee wants to do or not. Another thing that's unique to Washington is a variance application. You can apply for a modified rest or meal break requirement with a showing of good cause. And good cause just means when your circumstances warrant an alternative procedure that would not have a harmful effect on the health and safety welfare of the employees involved. And it's up to the Department of Labor and Industries whether or not they're going to approve that variance, but it's worth a shot. Let's say you have a schedule that just based off of when patients want to come in, it makes sense to have a schedule that's going to put a lunch period at 5.5 hours, not 5 hours. Apply for a variance, see if it's granted. And that might be an easy way to avoid a violation. Another example would be if for whatever reason, the lunch period needs to be 25 minutes instead of 30 minutes. If you have a good case for why that is, apply for a variance. And again, that's something we can help with.
And we're helping a client in Washington with that medical dental practice right now. So, hopefully that will work, but it is something to try depending on your practice or what type of business you have.
Now, Oregon doesn't have the exact same thing. It's a little less clear cut in Oregon. If you can demonstrate an undue hardship on the operation of the business, you can complete a notice to employees regarding meal and rest periods and provide it to affected employees. And then you kind of you've put the employee on notice, and I should preface that by saying this is specifically for short meal periods. But you've put the employee on notice, hey, it's an undue hardship on us to provide a 30-minute meal period. So you're only getting a 25-minute meal period. Maybe, a court agrees with you that you have met that definition of undue hardship. Maybe it doesn't. In my mind, that's a risky route to go, as opposed to the variance in Washington, where you're basically getting approval from the Department of Labor and Industries to do what you've set out to do.
Okay, so we've got some other practical tips to consider. The first is, and I talked about this a little bit earlier, train or retrain your managers and employees. And I would do this separately. And again, training is something that Alex and I can do for you. It can be a webinar like this, or it can be live at your employer in any sort of state on the West Coast. But I think training them separately is important because there are some, especially in some smaller medical dental practices, issues with things being LLCs and potential personal liability, depending on the claims and depending on the state. And you really need to, I don't want to say make it scary, that sounds sort of bad, but make it real, because these are very real issues with huge potential exposure. I like it when employers can have meal rest periods or whatever you want to call it. Somebody who is in charge of making sure that you're doing audits, making sure that you're flagging the things that need to be flagged, making sure you're knowing what the records there are, and making sure that discipline is happening. And if that person can be accountable and it's part of their performance evaluation or their job duties, that is a very good thing, because I think meal and rest period issues are one of those things that gets lost because it doesn't really come under anyone's particular job duties. It's not exactly HR, it can be payroll, but having somebody who's accountable for it is really, really important. And that's something that we recommend. Next, conduct regular internal audits. Again, they can be sample size. They don't have to be your entire employee population, but you want to conduct those audits. And if you want them privileged because you're worried you have a huge problem, let us or let your regular counsel know and have them conduct that audit. Next, check in with your employees. This, depending on their size, can be a difficult thing, but if you're talking about the sort of 250 less employees, just occasionally checking in with them and saying, how's it going? Are you able to take your lunch breaks? Are you able to take your rest breaks? If you can't, what's happening? Goes a long way in the goodwill of your business, but also goes a long way to finding out problems that might not otherwise be reported. And next, look into wage and hour EPLI insurance. Now, what I'll tell you is very few insurance companies cover wage and hour, have wage and hour coverage. And even when they do, sometimes it just goes to attorney's fees and not the actual claims. And it might be cost prohibitive, but it might also be worth looking into for your business. Talk with your payroll vendor about system changes or options that might be there, especially if you have one of the larger providers. Like we talked about before, make sure you're flagging non-compliant meal periods. Do not round. If you are doing any sort of rounding for meal periods or clocking in and clocking out, don't do the rounding. You need to make sure and have that 30 minutes. One of the things that can be really helpful is drop-down menus for non-compliant meal periods. Finding out, was the employee provided, did they have the opportunity to take a meal period but didn't want to, or were they not given the opportunity to take the meal period? Requiring the attestations of accuracy and compliance. Consider requiring employees to attest to timesheets accuracy and compliance, ideally per day or per pay period, depending on your timekeeper's capabilities. And I know we're running out of time, but this one is sort of a small thing, but I just want to bring it to your attention so that somewhere in the back of your mind it's there. If you have employees that are putting in their own time, maybe on a computer or something, handwriting it, be very leery of exact 30-minute meal periods, because chances are if somebody is putting in 30, 30, 30 every day, that they're not actually taking that 30. And I know that's going to be what's written down, but you want to still go back to that employee and say, you have to be keeping track of your actual time. All right, so yikes, we aren't doing it right now. Now what do we do? There's a number of things we can do. The first is correct it. You've got to, if you're in the medical field, you've got to stop the bleeding, right? This is going to cut off the liability moving forward, and it's going to start the statute of limitations running on those old claims, and they're going to drop off sort of day by day. Depending on what the claim is, the statute of limitations can be anywhere from 3 to 5 years. So these are long-term claims, and there can be employees that are long gone that now you're dealing with. So make sure you correct it. 2, assess how widespread the problem is. Is this a random one-off thing that just 1 or 2 employees is having a problem with, or is this a system-wide problem that you don't realize is happening? 3, assess your potential liability. We can help you do that. You can look at it yourself and do that, a quick and dirty, oh my gosh, we've got 30 days and we've missed 30 meal periods. We've got a problem, right? And weigh the business risks of proactively compensating employees for the non-compliant meal and rest periods. This is a tough one. It may be an individual business decision. You may need to talk to somebody about it and figure out what you're doing. But if you don't know whether you have meal period problems, you don't know what your risk is, and you don't know how the best way to fix it is. But often proactively compensating is a good way to go. And I know a lot of employers worry that it will be misused, but remember, it doesn't mean that you can't discipline the employee, right? So let's say you have an employee who serially takes a 25-minute meal period and you're thinking, oh my gosh, I'm paying this employee an extra 30 minutes every day. Discipline that employee. And eventually that employee will either straighten up or fly right, or you can terminate them. And then if the employee has left or is leaving or is threatening you and you want to sign a severance agreement, please, this is going to be the keep calm and contact your lawyer, but please contact somebody about a severance agreement, a counsel about a severance agreement, because you may need to offer more than what is owed or what is disputed. And there are certain requirements for what can and cannot be said in settlement and severance agreements in both Oregon and Washington, and certain types of claims have to be approved by the court. So there's a lot of tricky issues when you deal with severance and settlement agreements that you need to be aware of. So obviously this is a lot of information to cover in a pretty short period of time. I know we still have a lot of questions. Alex, do you want to start going through that? And we're happy to stay on the line a little bit longer, Martha, our administrator, if that's okay, to try to answer some of these questions, because I know it's a lot of information and there's a lot of confusing and detail-oriented things that deal with different businesses, or that different businesses have to deal with.
Yeah, so I'll start with this question. If we have waivers signed on file and they take a 25-minute lunch, does that still need to be paid? Or are we okay since we have the waiver? You're okay, you have the waiver. The only caveat with that is that the waiver can be revoked at any time. So you do want to kind of try to generally follow the law in that situation. So if all of a sudden all your employees revoke their waivers, you're not left with a systemic problem. But yes, if you have an active waiver on file, you're good. If all employees voluntarily write a waiver that they are okay with a meal period of 5.5 hours instead of 5, is that enough? Yes, but I would, like I said, I would work on a specific waiver form, probably working with counsel. Leah and I would be happy to help you with that, to make sure that it's giving you the best possible argument for a waiver by the employee. For Washington State, is there a specific waiver form or just document with signature stating the information? Again, there's not a specific one provided by the state of Washington, but we can help with that. If the employee, while on their lunch or rest time, receives a text or email from a client, patient, coworker, boss, etc., and they choose to respond, is that considered an interruption? Yes, that is considered an interruption. In the state of Washington, does meal break waiver have to be signed for each occurrence, or just have one signed on file? One signed on the file is fine. What about undue hardship waiver in Oregon? What if you are performing surgery and there is no other staff member that can substitute? Again, I think the undue hardship situation is a little difficult to rely on in Oregon. I think that's a situation where you just pay for that specific meal period and move on. Let's see, do we still pay for 30-minute meal period? I know that question seems to be cut off. Can you provide an example of a written waiver? It's going to vary depending on your organization, so it's hard to kind of provide a one size fits all. But generally the waiver is going to say, reiterate, the employee's knowledge of meal and rest period laws, notwithstanding that they are voluntarily agreeing that they're going to waive their entitlement to a rest period. Does a waiver allow an employee to not take a lunch at all during a shift? Yes, it does. We use the waiver that Washington State provides. Is that enough? I'm not sure exactly what that's referring to, which waiver that's referring to. So I would have to see that specific waiver. Where does one find an employee waiver? Again, in Oregon, if you have in the restaurant industry and it's a tipped worker, that's something that is a form available by BOLI. If you're in Washington, it's something that you will have to prepare. If an employee signs a waiver but still takes a lunch, is it a violation if the lunch is after the 5th hour? No, because you have a waiver. Let's see.
We did have a couple questions about, what if somebody wants to leave early and use their lunch period? And in both states, the statutes are pretty specific that you're not supposed to be using meal periods to come in late or leave early. So you can't, that would violate a number of the issues, the timing of the meal period, as well as, you're not getting a break during the day, which is what meal periods were designed to do. So if an employee needs to leave early, they need to leave early. Maybe if they're decreasing the length of their shift, it's going to change whether they need a meal period or not, but you can't use the meal period as the leave early basis.
Here's another one. Can employees clock out for lunch at hour 6 or hour 5:59 and before? It's going to depend on the state. So, I think in Washington, it has to happen right at hour 5, for example.
It's between 2 and 5, so it would have
right,
to
so
start between
right.
2 and 5. So once you get to 6, it's too late. Or once
right,
you,
and
yeah.
then in Oregon, it's 6. If the shift is at least 6 hours, the meal period is to be taken after the 2nd hour work and prior to commencement of the 5th hour worked. So, oh no, sorry, I meant to look at it prior to the commencement of the 6th hour work if it's a longer shift. So you want to take it at 5:59, not 6. But again, you probably don't want to be cutting it that close and set a schedule where employers are probably going to be taking their lunch more than just 1 minute before the cutoff. Do you have any recommendations for time card apps? I do not. Leah, do you?
No, I think going with the bigger ones is better. The ADP sort of one. I think Paycom does one. We'd be happy to get back to people, but the bigger one, any provider that does business in California is usually going to be able to do these things because California was sort of the front runner in having, and is still the land of giant meal and rest period violation cases. So, and I would just, if you're interviewing people, I would just ask them what their capability is to do some of these things.
Here's another one. If we have a waiver, do we still pay for the meal period? I guess if there's a violation, no, they've waived that. If there would normally be paid for a meal period, then I think yes. Like, let's say you're saying, hey, everyone is getting a paid lunch. I would just go ahead and pay everyone for that lunch. How can you calculate meal periods and rest breaks for exempt employees? So exempt employees are not entitled to meal and rest breaks, so you don't have to worry about that. Can employees waive their rest period in lieu of getting a paid lunch period? No. A waiver in Oregon is it a waiver in Oregon irrelevant unless it's a food service employee, not relevant in dental or medical? That's correct. You can't get a waiver in Oregon in those fields. If lunch break time is 45 minutes unpaid and the employee was interrupted for 5 to 10 minutes in between, do we still have to pay 30-minute break, or is it okay that the employee had 30 to 35 minutes total? I think how that works is they have to have 30 minutes uninterrupted. So let's say that it depends when that interruption happened. If that interruption happened early on and then they got the full 30 minutes, then you're good. Can you review the requirements of a staff meeting during lunch that is paid? So they get paid for that lunch, but they still need a 30 minutes uninterrupted. Mm-hmm. That's not work related. I've been in the dental field for over 10 years. I've never been offered or taken a rest break. How would an office go about offering that when there is not an efficient way to schedule for this? So again, it's going to depend on who the employee is. If you're a dentist and you haven't been offered a rest break, there's a reason for that. You're exempt. If you're a dental assistant and you haven't been offered a rest break or it's not documented, I think depending on if you're in Washington, an intermittent rest break might make more sense than a designated 10 minutes. If you're in Oregon, you don't have that option. And it's just looking at the schedule and figuring out when does it make sense for these rest periods to occur? How can we stagger them amongst our dental assistants or other non-exempt staff? As far as I understand, you can pay for the meal period, but you still have to provide a 30-minute uninterrupted meal regardless. Isn't that right? Just because you pay them doesn't mean that you can short their meal or not take one, right? That's right.
Unless there's the waiver.
Right. Let's see. Can you review what to do in emergency situations again in Oregon? So I find it very confusing what BOLI says about emergency situations. There are, let's say there's a earthquake and you don't get your meal period. Well, yes, that's going to fly under the emergency situation exception for not providing a meal period that day. Everyone was just trying to get to safety. But I wouldn't rely on that heavily.
Yeah, so what BOLI says is that if there's sort of an act of God, for lack of better words, or exceptional and unanticipated circumstances that don't happen very often, right? So if this is a one-time thing, a police incident happens or a natural disaster or one of those sorts of things, then yes. But if it's something that happens even somewhat regularly at your practice, patient issues, emergency, dental issues, whatever it is, then no, it's not going to be considered an emergency situation. It's not going to be a reason to not give the meal period in Oregon. I will say that the one thing in Oregon, the one little silver lining that Oregon has is in Oregon, if you paid the meal period and didn't give the continuous 30 minutes, but you paid it, then there doesn't appear, I will tell you because it's unclear, but there doesn't appear to be a cause of action for that. So if somebody didn't get paid, it's one thing, but if they got a paid meal period, it does not appear that in the situation like you have in Washington where that you'd still have to pay. That's not, I hope that I made that clear, that's not the same in Oregon. So that's why we see less meal and rest period class actions in Oregon as opposed to Washington, where I bet we see, Alex, 4 filed a week. And
yeah, and another difference is that there, at least for now, isn't a private right of action for a rest period violation in Oregon, but there is in Washington.
Right.
But you can still be on the hook for it with the Oregon Bureau of Labor and Industries. So if they get wind of you not complying with rest breaks, they can make your life difficult as well. But at least
that's right. It's just exposure. That's right. And the one headline that we had in here at the start, it was a huge employer. It's legacy, but BOLI went after him. The Oregon Bureau of Labor and Industries went after him for roughly $100 million worth of alleged damages. Now, that's obviously a huge employer, and Legacy is fighting back, actually hitting back quite hard. But that shows you that if BOLI goes after you, they can make some, they can make some real problems for an employer. So I think we covered all the questions. We still have quite a few of you online. I have Alex and I's contact information up here. Please don't hesitate to reach out. I know a lot of you are not huge employers and you're thinking, oh my gosh, the cost. But this is one of those areas where an ounce of prevention is worth 25 pounds of cure, because these cases are so expensive. Spending the $1,500 or the $2,500 or even the $5,000 up front to take a look at your records or to get a waiver that's going to be effective. Something like that is quite quick. The waiver is really worth it. And like we said, these cases are coming up all the time, and there's a particular law firm in Washington that is hitting medical and dental offices in particular. And I don't know that it's okay to say that name of that lawyer, but he's very good at what he does, and he is unyielding and does not care that you're having to, that people might be missing their breaks because of patient care. He just does not care about any of that. He says, this is what the documents say, and if I have to go after individuals, I'll go after individuals, which is part of the reason that prompted us needing to do this, is our own clients and then hearing from this guy and seeing the amount of lawsuits that are being filed. So if there are any other questions, let me see, did any pop up? Otherwise, thank you all so much. We hope that this was helpful and not over terrifying. And we thank you for being part of our webinar today.
Thank you.